Welcome to Part 2 of Washburn University School of Law's video colloquium, exploring the socio-legal issues associated with COVID-19. I welcome you to contact any of our faculty members in the video if you have questions about their presentation. And I would like to thank you if you sent us a note of gratitude about Part 1. We definitely enjoyed hearing from you and providing this service to you. Enjoy.
Hi, and greetings from Lawrence, Kansas. I'm Joseph Masher-Simone, the Associate Dean for Academic Affairs at Washburn University School of Law in Topeka. I'd like to talk to you a little bit today about how a somewhat little-known provision of the National Labor Relations Act applies to the current COVID-19 pandemic issues and the pressures that it's putting on employment. Please note that obviously the National Labor Relations Act is not the only statute that's putting pressure on the employment relationship. There's a host of legal issues that's arising in employment. I want to talk about just one small piece of that today, and that's the National Labor Relations Act. It seems fitting to talk about the National Labor Relations Act. We're in this period of time when we're told to stay distant, to stay apart, to separate. At the same time, we're told that we're in this together, that we're doing the separation to help achieve social aims. We are acting together. We are acting concertedly to protect individuals in society and society as a whole. And given that context, it seems appropriate then to focus for a few minutes on the National Labor Relations Act. It is unique in that it is the only statute in federal law that deals and protects specifically with times when employees are acting together to protect themselves, acting together to protect labor as a class. And therefore, it is appropriate to look at how that statute applies in terms of today. It doesn't take too far to find NLRA issues in today's news. Take, for example, Amazon. A few days ago, there was a work stoppage at its facility in Staten Island, New York. Employees walked out on the job to protest unsafe working conditions related to COVID-19. And Amazon ended up terminating an employee who was organizing that workplace stoppage. The Amazon has arguments for why that was legitimate. The employee allegedly did not return to work after he was told not to because he was exposed to COVID-19. And that was the reason for his discharge, so says Amazon. And Amazon might be right. Amazon might ultimately win the legal battle here. But the critical point to consider is that that may not matter. That is the court of public opinion that this is going to be litigated in, and not the sleepy halls of the National Labor Relations Board or even federal courts on appeal. Take, for example, the tweet from Senator Bernie Sanders here, calling Amazon out for its actions and siding with the employee who engaged in the actions. Amazon's not going to be alone in seeing this kind of reaction from its employees when there's allegations that there's unsafe working conditions related to COVID-19. So what's the legal backdrop? What's the law that's behind the scenes? Well, here in the Amazon case, it's primarily Section 7 of the National Labor Relations Act. And Section 7 is the central promise, the central right of the statute. And it provides employees with the right to engage in concerted activities for the purposes of collective bargaining or, quote, other mutual aid or protection. And it's that provision here that's really coming into play. A few things to note about the Section 7 right. So first, employees do not need to be represented by a union in order to have a Section 7 right to engage in this activity. This is a right given to all employees who are working for employers who are engaged in interstate commerce. The person must be a covered employee, obviously. That in some sense, that means they can't be an independent contractor. That's an easy line to draw. Of course, that does carve out all of our gig economy workers who are often classified as independent contractors. And the employees must work for a covered employer. There are many exceptions for coverage under the National Labor Relations Act. The largest is for government employees. So federal workers and state workers and local workers are not covered by the statute and must find protection elsewhere. Obviously, the employees, by the terms of Section 7 and the nature of the statute, must be working in concert. They must be acting together. It usually takes two to tango here, although you can envision scenarios where one employee can be acting in concert. So, for example, the employee could be asking others to join him or her in concerted activity. They could be bringing group concerns on their own to management's to make that aware to management. They could be making group concerns aware to the public. An important thing to note here also about Section 7, it doesn't just cover strikes. So the employees in Amazon walked out, but they didn't have to. They could have done other things and still found Section 7 protection had they gone to the newspapers, had they taken to social media, had they engaged with state and local authorities. That all would have been protected concerted activity under Section 7. They must be acting for mutual aid or protection. Obviously, that what they're doing must be related to work in some way, either related to their own terms and conditions of employment at their own place of employment, or in a sense to better the lives of workers as a class, as labor as a class. That would also be mutual aid or protection. And then the action must be protected. So employees can't engage in illegal conduct and then hope to cloak that with the protection of Section 7. So workplace violence would not be protected. Other exceptions could be seen, disparaging the employer's product would not be protected product, but speaking disparagingly about the employer's policies or safety protocols at work, that would be protected conduct. When we're talking about safety concerns and Section 7 actions, mostly dealing with workplace stoppages, so long as the employees have a subjective good faith belief that there's a safety concern, then Section 7 is going to easily apply. Fairly low bar there. One caveat, one warning here to employees: if they go out on strike, if there's a work stoppage, for these reasons here, this would be considered an economic strike, an economic work stoppage, and therefore the employer would have the right to permanently replace those employees. They could not be discharged, but they could be replaced so that when the work stoppage ends, they would have to wait for a job opening to occur before they would get an opportunity to have their job back. The employer would not be required to discharge the replacement workers. Juxtapose Section 7 with Section 502 of the NLRA. It's a bit of a sleepy section of the statute. It doesn't get a lot of play except in times like this. It got some play when Ebola had an outbreak a few years ago. It even got some play during Y2K. And here we are again with COVID-19. So Section 502 essentially says, look, employees who go out, who quit their work because of a good faith belief that there are abnormally dangerous working conditions at work, we don't consider them to be strikers. So what does that mean? What's the practical effect? Well, that essentially provides those workers with some enhanced protections. If they're not strikers, then they can't be replaced as strikers. And so they could not be permanently replaced. They can't be discharged. They can't be permanently replaced. They have some extra protections that the Section 7 strikers, economic strikers, don't have. Well, along with the extra protections come with some extra burdens of proof. So a Section 502 strike would be found only when the employees believe in good faith that working conditions are abnormally dangerous, not just dangerous, but abnormally dangerous. That the belief is a contributing cause of the work stoppage. It doesn't have to be the only cause. There can be others, but it has to be one of them. That the belief, and here's the kicker, is supported by ascertainable objective evidence. It's not enough, unlike in Section 7, for the employees to have a subjective good faith belief, but it has to be backed up by some objective evidence. And then finally, that the perceived danger imposes an immediate harm, immediate threat of harm to employee health or safety. Don't read too much into immediate. The board has said that that can be over a longer period of time. For example, a low-level exposure to radiation over a long period of time. The cumulative effects of that, the board has said, poses an immediate threat to harm, even though it's not an immediate cause and effect. How does all this apply here to COVID-19? You can see easily the arguments that employees could make. If there's a work stoppage, if imagine an employee is diagnosed or a member of their family is diagnosed with COVID-19, and the employees walk out thinking that the workplace is now an area where they can, where the virus can be transmitted. Are they working in abnormally dangerous circumstances? No, they're certainly more dangerous than normal. You would not normally expect in an average workplace to be exposed to a deadly disease. That seems abnormal in the common sense meaning of the word. Is the belief a contributing cause of the work stoppage? Probably, as long as if there are other things at play, that's fine, as long as it's one of them. Is the belief supported by ascertainable objective evidence? Are they just being irrational? Is there an irrational fear? Given what we know so far about the disease and how it's transmitted and the serious consequences for some that are diagnosed with it, there seems to be enough support that it's not irrational, that it's not just subjective, that it's based on some objective evidence. And is there a perceived danger, an immediate threat of harm to health and safety? Well, sure, yeah. If long range, low dose exposure to radiation is sufficient, surely a 14-day incubation period is probably more than enough to meet the immediacy of the statute. These are important things for both employees and employers to think about. These are rights that employees often forget that they have or never knew that they have, particularly on the Section 7 end of things. They think, well, they're not part of a union, so they're not protected. Not so. These are rights inherent as employees covered by the statute. And to the extent that Section 7 isn't well known, Section 502 is barely even given a second thought by employees. But it's important that they know they have these extra enhanced protections, but that there's extra enhanced proof that must be provided. So careful counseling of employees is important here. Same too on the management side, on the labor side. Employers should be well aware that employees have both Section 7 and 502 rights here. If employees are going to the press, if they're going to public, if they're going to social media to complain about employer safety, COVID-19 exposure, cleaning protocols, that's protected by Section 7, so long as that they are engaged in protected activity. They're not doing things outside of bounds. That's protected, and those employees could not be discharged or they could not be disciplined. Same on the 502 end for work stoppages. The 502 certainly is going to limit the employer's response and how it responds to a work stoppage. I hope you found this very quick video helpful. There's certainly more information out there about both Section 7 and Section 502. There's information here on the slide. I hope everyone is well, remains to be well. Hope you found this informative. Special thanks to Professor Rubenstein for being the leader in the faculty colloquium on COVID-19 and its effects on the law, and to Glenn Macbeth for putting together all the technology on the backside. Thank you. I hope you enjoyed it.
So in this segment, I'll be discussing the public international law aspects of the coronavirus or COVID-19 pandemic. That is, how the law that governs interstate conduct is implicated by the pandemic. Now, the relevance of international law may not be immediately obvious, but the reality is that global pandemics are quintessentially an international problem. Indeed, the very definition of pandemic emphasizes the global international nature of an epidemic. A virus respects no borders, it can spread around the world, it poses a threat to all of humanity, and thus a global response is required to address the crisis. And the legal regime that governs interstate action and behavior is therefore directly and significantly implicated. There are, of course, many aspects of public international law that are implicated in all sorts of different ways, but in this short segment, I'm going to just touch on a couple of them. So to begin with, I'm going to look at the obligations that states have to other states in how they respond to a pandemic. And this includes both the obligations to prevent the spread of the disease and the constraints imposed on states in how far they can go in responding to the pandemic. Secondly, I'll look at the obligations of states to people within their territory. And this again includes both affirmative obligations to people within the country to protect them from the disease or from the pandemic, as well as constraints on states not to violate the rights of people within the country in their efforts to respond to the epidemic. So to begin with the obligations of states to prevent the spread of disease, the starting point is the so-called no harm principle and principles of due diligence. Now, all states have obligations under international law to prevent activity or conduct within their territory from causing harm to other states. This is commonly associated with environmental law to transboundary harm from pollution, but it also applies in the context of response to epidemics and creates due diligence obligations to make best efforts to identify the risks or threats of an epidemic and to prevent the spread of infectious diseases to other states. And this applies to all states, not only the state in which the infection originated, but all states have an obligation to take steps to make best efforts in line with their capabilities to prevent the spread of infectious diseases beyond their borders. Now, these general obligations have been refined and codified to some extent in a treaty, the International Health Regulation, or the IHR, which is overseen by the World Health Organization, or WHO. Now, the WHO is an international organization that was formed in 1948 by a treaty that now has 194 state parties, including the United States. The purpose of the WHO is to serve as the directing and coordinating authority on all international health work. And it was given the authority under its founding treaty to promulgate regulations specifically designed to prevent the international spread of disease. And so the WHO did so in 1969 in the form of the International Health Regulations, or IHR, which comprise a separate treaty overseen by the WHO. Now, the IHR was significantly amended in 2005 after the SARS break in order to expand the scope of pandemics that would come within the scope of or under the purview of the IHR. And there are now 196 states that are a party to the IHR, again, including the United States. And the purpose of the IHR is to, quote, prevent, protect against, control, and provide a public health response to the international spread of disease in ways that are commensurate with and are limited to public health risks, and which avoid unnecessary interference with international traffic and trade. And so the IHR imposes a number of specific due diligence obligations on states, including the creating and maintaining of the capacity to deal with an epidemic, and obligations to immediately inform the WHO and the international community more broadly after the emergence or spread of infectious diseases that pose an international threat. Also, significantly, it imposes an obligation to base health measures responding to an infection on scientific principles and to collaborate with other states and to cooperate with the WHO to the extent possible. Now, under the IHR, the Director General of the WHO can also determine that a spreading infection constitutes a public health emergency of international concern, or a PHEIC. And states are required to take appropriate measures in accordance with advice and recommendations of the WHO in their response to the disease. So as noted, the IHR and the WHO try to strike a balance between, on the one hand, actions to help protect populations from the spread of disease and to treat those who are infected, and on the other hand, limit the disruption to international trade, to free flow of peoples, and other aspects of the global economy. Which brings us to the second aspect of obligations of states to other states. And this is that aside from the obligations of the IHR itself, international law constrains to some extent how states may respond to a pandemic. States may want to take defensive measures that may violate other international law obligations in agreements on international trade, free travel, refugee law, finance and investment agreements, and so forth. Consider the closing of borders and travel bans that have been imposed by many countries in the current pandemic. These may violate other obligations. Now, some of those violations can be justified under exemptions and derogation clauses in the relevant treaties, which can be invoked in the case of emergency or crisis, but others may not. All of this requires complex issues that have to be analyzed in their specifics. But let's turn then to the second set of obligations. These are the obligations of states to the people within their territory. And again, here there is an obligation to prevent harm, and there are constraints on the measures that states can take in response to pandemics. So to begin with the affirmative obligations, the starting point are really two treaties that form the bedrock of human rights law. These are the International Covenant on Civil and Political Rights, or the ICCPR, and the International Covenant on Economic, Social, and Cultural Rights, or the ICESCR. These comprise the core of what is commonly referred to as the International Bill of Rights. These provide for a right to life and a right to health and well-being. And together, these rights require states to take affirmative action to protect the people within their territory from the threat posed by a pandemic. The ICESCR quite specifically requires states to take steps for the prevention and treatment and control of epidemics, while the ICCPR provides for the right to life of all human beings. And this right creates an obligation on states to protect people from threats to the lives of individuals, even threats from natural causes such as pandemics. Moreover, the right to life is of course a non-derogable right, meaning that the state cannot suspend or derogate from its obligations in times of emergency or crisis. Now, this is relevant, of course, to the recent suggestions that government responses to the pandemic have been overreactions, that we should be willing to allow some number of deaths in our society in order to safeguard the economy. And aside from the profound moral, ethical, and other objections to such arguments, government inaction in the face of a clear and present danger of a pandemic would be a clear violation of international law obligations, the violation of their people's rights to life and health and well-being. But international human rights law also places constraints on how states can respond to the pandemic. In trying to respond to a pandemic, states may want to isolate people, place them in quarantine, limit travel within the state, use electronic surveillance, such as cell phone data, as has been used in Singapore and Israel to track and monitor those who have been infected, to use force to enforce social distancing regulations. We've heard of excesses in countries like Kenya in just the last few days. All of these can trigger human rights issues, potentially violate the right to liberty, security of the person, association and assembly, freedom of movement, the right to privacy. Now, some of these may be derogations from the rights or obligations justified by the crisis, but they may also be violations of non-derogable rights. And again, this requires careful analysis. So in conclusion, all of this has been really just a very brief, very high-level look at some of the international law considerations and implications of the pandemic. There are, of course, many nuances to all of this. There are debates over the scope, over compliance issues, over the extent to which any of this can be enforced. And we could spend a lot of time talking about how all of this applies to the current facts in the context of the COVID-19 pandemic. There's already been a lot of finger-pointing over responsibility for the spread of the virus, but none of that's really particularly helpful right now. Pandemics are by their very nature global problems which require international coordination and cooperation to combat and to overcome. One of the tragedies of this pandemic is that so far, no country is really taking the lead, and there has therefore been an absence of cooperation and coordination among the major powers. Now, I'll leave you with, for those interested in further reading on this, I would really suggest these 4 blogs on international law and national security law, which have been covering the COVID-19 pandemic carefully, and as well the WHO website. So with that, thank you and stay safe.
Hello, my name is Andrea Boyack, and I'm going to talk to you about the economic impact of the COVID-19 shutdown of multiple parts of our economy and the legal responses to that. In this part A, I'm going to be focusing on the economic impact to individuals and households, families, and in part B, I'm going to focus more on the market as a whole and on businesses. Now, we are dealing, as we know, with not just a medical emergency, this global pandemic, but an economic crisis. In this country, there's been a near complete economic shutdown throughout the country. And really the governments felt that there was really 2 bad choices: letting the virus spread exponentially, not quote unquote flattening the curve, leading to potentially catastrophic loss of life, or to stop the virus from spreading, basically treating everyone as if they could be infected and having social distancing, and even more extremely, requiring people to shelter in place, quarantine. So as an attempt to try to reduce the deaths from COVID-19, we have had orders to shut down multiple businesses, almost all non-essential businesses. And that's true as of Tuesday, the 31st of March. We have 270 million people in at least 33 states, 89 counties, 29 cities, the District of Columbia and Puerto Rico, all being urged to stay home if they do not work for essential businesses, which is defined as hospitals, certain government workers, food providers, and the like. And this has led to a massive economic slowdown, a recession, if you will. But it's unlike any recession that we've seen in the past century. Most of the recessions that we've seen in the boom and the bust of our economic cycle pertain to investment spending collapse. the dot-com bust, the foreclosure crisis. And the way the government dealt with these was to slash interest rates or buy assets. That's really not going to help a service sector recession. This recession is caused by depressed activity in the service sector. And interestingly, the service sector is traditionally seen as a source of economic stability, as opposed to the investment sector, which is more of a source of volatility. People go out to dinner and get their hair cut and go shopping and go see a ball game, even when the stock market crashes. But now they can't do any of those things. They are ordered to stay home. There are different people who are impacted by a service sector's recession as well. The people who are most impacted are the people who lose their income by being forced to stay home. And that often is hourly paid employees. They make up 2/3 of all retail, leisure, hospitality workforce, and most of them cannot do any of their job from home. They also are among the most economically fragile segment of our population to begin with, already facing difficulties staying housed, paying for food, and paying for medical costs. So what happened with the shutdown is we had a huge surge in unemployment filings. If you look at the 3.3 million people who filed for unemployment in March 2020 and compare it to the increase during the 2008 recession, for example, you will see that we have a massive number of people in our economy who no longer are getting an income. And so they are overrunning local offices and filing for unemployment en masse. Usually unemployment only replaces less than half of an income. However, with the CARES Act, that's the Coronavirus Aid, Relief, and Economic Securities Act, signed into law on March 27th, the federal government will provide an additional $600 a week or up to someone's full income replacement for 4 months if laid off during this crisis. That hasn't actually been rolled out yet, but when it does, it will provide a lot of relief for these people. And also, the CARES Act importantly covers for the first time people who are self-employed, freelancers, and workers in the gig economy. They were ineligible for state unemployment benefits before, but under the Pandemic Unemployment Assistance Program created by the CARES Act, they will be able to get a $600 payment. Some workers are not actually fired, but they can't come to work because they're sick or they have new caregiving requirements due to their children being out of school or a family member with COVID-19. This is a problem because most states and the federal government do not provide a mandate that employers pay for sick leave. And therefore, people who are living paycheck to paycheck and at this very financially fragile part of our economy, they really cannot, they have to choose between, do I earn money to live or do I go to work sick? That's a problem, of course, in times of a pandemic, and the federal government reacted by passing on March 18th the Family's First Coronavirus Response Act, the FFCRA, which provides federal funds enabling small businesses the ability to let people be off for up to 2 weeks of paid leave if they or family member need care because of COVID-19. This was done in an effort to contain the crisis, but it really does highlight the question of whether or not there should be paid leave mandates in our society. Because people, especially the lower income households, are already living at the edge of their financial capacity. Paycheck to paycheck, their budget is eaten up by 50% or more of housing costs, and they don't have enough to pay for things like food and healthcare. A loss or even decrease in income leads to a whole collection of other collateral harms. You have the problem of people becoming potentially unhoused, which is why you have foreclosure and rental moratoria being enacted by the CARES Act to push out the date that they will have to pay those housing costs. Of course, that's a problem because it's not necessarily true that they'll be able to pay it later. It's not like the income's deferred, it's just lost. However, it will at least keep people housed, which is a big part of the solution. To have a delay. Another problem, food insecurity. We have had a little bit of a supply chain disruption and hoarding, but the bigger problem is a lack of income of people to buy food. We have food programs that have been themselves disrupted by the shutdown, particularly the USDA's school lunch program and school breakfast children that serves 35 million children every day. How do we get these children food? The law does not mandate the USDA food programs to continue when the schools are not operational, but many local school boards are taking matters into their own hands and trying to provide food for these children who are dependent on the school lunch and breakfast programs, basically for their food needs. We also have the food stamp program, the Supplemental Nutrition Assistance Program, or SNAP, that was recently targeted for reduction. There were going to be an elimination of benefits for more than 1 million households with children. That was being proposed right before the crisis. Now the CARES Act has included a $15.8 billion appropriation for SNAP, so there can be some emergency benefits provided to families who are already enrolled to cover the food costs. Healthcare access and costs is another question. Our health care in this country is very expensive, and health insurance is often tied to employment. Now, that means when people are laid off, they lose their health insurance, and that's in the middle of a pandemic. That's a problem because we're swelling the ranks of the already 27.5 million people in this country who have no health insurance at all. And even people with health insurance might, or are more often than not nowadays, have very high deductibles, and making it even unaffordable with health insurance to seek medical care. This discourages people who need to seek medical care from seeking medical care, which can create more fatalities and adverse consequences from something like COVID-19. And it also could leave people with massive medical bills that they are unable to pay. And already, even before the pandemic, medical bills was the #1 trigger for personal bankruptcy. The CARES Act does provide that testing and potential vaccines for COVID-19 will be covered by the government at no cost to patients, and it does also mandate that private insurers cover COVID-19 treatment. Again, that's wonderful news and a wonderful step for people with insurance. It doesn't cover treatment for people who are not insured, however. Now, let me talk a minute more about the CARES Act, the Coronavirus Aid, Relief, and Economic Securities Act. It not only provides this unemployment payment expansion, which I mentioned, and a moratoria on foreclosures and evictions to keep people housed. It also provides some housing subsidies to help support affordable housing that's administered through public housing authorities at local levels, and sets up emergency money for localities to further support housing needs at providing maybe deposit assistance or emergency shelters. But it also, interestingly, provides for stimulus payment. That's $1,200 per person, plus $500 per dependent child. And there's no income floor. It doesn't matter if you paid any taxes, although you have to have filed your tax return in 2018 or 19, but it doesn't matter what your income was or if it was zero in those years. You still are entitled under the Act to this one-time $1,200 per person payment up until your income is $75,000 per year with an allowance for children. And then there's a scaling down of the amount you'll get until there's no stimulus payment to anyone who makes more than $99,000 a year. That's a wonderful payment. It probably is not enough, particularly in places on the coast where the cost of living, when you include housing, is significantly higher. It also might take several months to actually roll out. The 2008 stimulus plan took 6 months to pay, which means that although people might eventually get some money to offset their additional costs and decreased income due to the shutdown, it might not come quickly enough to be of any immediate help. There are also some problems related to loss of income that have to do with debts. Predictably, when people don't have money coming in, they might not be able to meet their payment obligations. I mentioned mortgages already, and CARES institutes, as I mentioned, a moratorium. It's actually a 60-day moratorium on foreclosures, but that's only for mortgages that are backed by federal entities, USDA, FHA, VA, HUD, Fannie and Freddie. And the moratorium actually could be extended to 6 months if the borrower requests and cites a hardship. Many borrowers do not have government-backed mortgages, and in those cases, really relief options are dependent upon what the servicer decides to do, unless there's an applicable state law, and some states have been passing some moratoria in the breach. With respect to student debt, the CARES Act mandates that the Secretary of Education suspend all payments that are due for federally held student loans until September 30th. That's an automatic suspension of payments. There's no interest accruing on the loans during that time, though all those months count towards as if they had been paid for public service loan forgiveness program. There's no collection efforts. There can be no credit reporting adverse effects. So that happens automatically. You don't have to pay a fee. There's some weird scam going on around that based on the CARES Act. And the Department of Education will notify each borrower that the payment has been suspended and advise the borrower with respect to how and when the payment will recommence. There are, of course, many other consumer debts, as I mentioned, medical costs, and some of these will lead to consumer bankruptcy. Prediction now is that there will be many more bankruptcy filings in the next year or two as a result of the shutdown that's going on right now. There have been, in the CARES Act and just before, some changes to the bankruptcy law. Because of COVID-19, people who are in a reorganization plan can modify it. That plan, which could be 3 to 5 years, can now be stretched out to 7. And there are some logistical problems with bankruptcy proceedings due to the shutdown that are currently being ironed out, like the question of whether there needs to be in-person Section 341 meetings of the debtor himself with the trustee. That gives the creditors the opportunity to show up and be heard, or whether that can be done through some sort of a web conferencing or something like that. And so that is what we're dealing with right now. And the CARES Act has been one of the very big first pushes to go back, and more in Part B with respect to the market as a whole and businesses. Hi, this is Andrea Boyack again, talking now about the market and business economic impacts and the legal responses to that for the COVID-19 shutdown. So we talked about how the shutdown of business, the shuttering of businesses, and all the non-essential working being mandated to stop and people staying at home had impacted individual people who are laid off. But of course, you have the same problems happening for businesses, especially for small businesses like restaurants, gyms, and salons, and things that are depending upon that sort of revenue of people coming, customers to their locations. Now, there are some responses by the Coronavirus Aid, Relief, and Economic Security CARES Act. In fact, that act does cover a lot of things besides individuals. Individuals get $560 billion of aid, but there's also $377 billion for small businesses and some $500 billion for big corporations, as well as state and local governments and public health and some other things of that nature. So we're going to just talk a little bit about what's going on in the realm of the market and the business world, and not just in individual households. One of the big issues has to do with commercial leasing, because many of the businesses that are shut down are things that have physical space, as we would say in the industry, bricks and sticks, and are dependent on people actually visiting those spaces and spending money in those spaces. That's the source of revenue. When people can't go there, they can't show up at the gym, or they can't go to the dance studio, or go get their hair cut, or go to the restaurant, you have a massive drop or even complete diminishment of the revenue that the property produces, which means that those particular businesses cannot pay their rent and are unable to keep operating per covenants in the lease. Now, rent obligations are covered by a lease provision, and there are provisions for rent abatement in cases of casualty. But casualty in commercial leases is defined with respect to the physical state of the premises itself. So if there had been a fire or a flood or a tornado or something, then there would not be a continuing requirement to pay rent until the business could open up again. But that wouldn't apply to the case of this sort of mandated, government-mandated, pandemic-inspired closure. There's nothing actually wrong with the physical space itself. And therefore, there's not a lease out for paying rent. Unless you can say that an act of God means an act of the government, really, you can't say that the lease would excuse a rental payment. Although you might be able to use the contract doctrine of sort of an extreme and unforeseen change of circumstances, impracticability and possibility, to avoid an operating covenant. An operating covenant meaning a promise to stay open certain hours and certain times. It's not going to really relieve you of paying rent. And in a way that makes perfect sense, because the landlord still needs to have that stream of income to pay its property costs that are not going to go away. Maintenance costs, capital costs for financing the property, etc. And unless the landlord's going to get a break on paying its mortgage, it needs to get the rental income as well. So you have this big gap between the money that's coming in, which might be almost nothing, and the money that is expected to come in. It's actually the same issue in common interest communities if people don't pay their assessments. Now, some have suggested that perhaps the way out of this problem is to have that gap funded by insurance companies through business interruption insurance policies. And in some ways, at first glance, that seems like it would make perfect sense. However, business interruption insurance policies define business interruption to not include non-payment of rent unless the non-payment of rent is caused due to physical loss, damage, or destruction of the property. And in that case, they might cover non-payment of rent during the restoration period. Well, again, that is a poor fit to what's going on today. And in fact, there is a possibility insurance companies do offer additional riders that can be purchased that would cover things like disease and pandemics and interrupted by civil authority types of business interruptions, but normally those are excluded. So there's a problem in that the insurance companies exclude coverage for the exact type of business interruption that we're facing right now. So that just leaves the landlord out or the tenant out or both. Some states are actually considering trying to deal with this problem by passing legislation that would require insurers to cover business losses from the shutdowns. This is pending in Ohio, Massachusetts, and New Jersey. I don't know if it will pass, and I don't know how much the insurance industry is going to push back if it does. So businesses are in trouble for rental reasons, for payroll reasons, for a lot of other reasons. They don't have customers, they can't operate, but they still need to pay per their contracts and per their leases. And business interruption insurance might not cover a pandemic. The CARES Act does provide some support for business owners. It allows for different types of loans, economic injury disaster loans up to $2 million plus an advance of up to $10,000 immediately. Also, the Small Business Administration non-recourse loan forgiveness up to 2 months for qualified expenses, which can include rental payments. There's the Paycheck Protection Program created by the CARES Act that permits the government to fund payroll for the small business. So the federal government will pay the payroll costs. Basically, that's done through a loan that then would be forgiven as long as the business maintains payroll. That means it doesn't lay people off. And then the CARES Act does provide some tax benefits, which I won't get into the details here, but basically they provide the businesses an expanded ability to use the losses that they're experiencing now to offset income at other times, and to also deduct more interest. Some large corporations and healthcare and agricultural business also need help and are getting help under CARES. There's $500 billion earmarked for loans, loan guarantees, and investments for large corporations that the Treasury Department will be distributing. $58 billion of that is going to the airline industry just to keep them open, because obviously people aren't really flying around the country right now. There are some protections in here designed to make sure that this is all on the up and up. The company has to disclose that they're receiving funds. They may not do a stock buyback for 1 year, continuing until the loan is repaid plus 1 year. Although many of these companies, to be fair, have just done a whole bunch of stock buybacks already. There's a special provision in the bill that bars the Trump family businesses from obtaining these sorts of special loans. And then they have some incentives to keep people on the payroll, but sadly, they do not require people to be kept on the payroll. And in fact, there's been a few cases, most notably the Kennedy Center was, there was some money earmarked to bail out the Kennedy Center, which is a performing arts center in Washington, D.C. And the very next day, the Kennedy Center told all of the musicians in the National Symphony Orchestra that they were being laid off and would be rehired again or considered for rehire once the NSO could start performing again. And so they all got laid off as of April 3rd is their last day, actually, and they're not going to have any health insurance. So that's an interesting thing that they didn't specifically require them to keep people employed. There's also $140 billion under the CARES Act that's going to support the U.S. health system, $100 billion to hospitals for their extra costs, I suppose, and then the rest to buy supplies and do training. And the act also increases the farm bailout amount from $30 billion to $50 billion. Obviously, having reliable food streams during this period of trade interruption is incredibly important as well. Oh, let me just mention before we talk about this that there have been some changes in business bankruptcy. In 2019, the Small Business Reorganization Act created a new subchapter 5 of Chapter 11 of Bankruptcy Code that small businesses could use to reorganize. The debt that could be restructured under that subchapter was capped at $2.7 million. The CARES Act increased that cap to $7.5 million, so it makes bankruptcy more accessible and helpful for small businesses who incur a lot of financial setbacks. And also, the CARES Act also authorized payment plan modifications that can help companies that are currently in bankruptcy. Now, the slowdown doesn't just mean people don't show up at the office. It means it's much harder to do deals of all different types of trades, conveyances, financings, ventures. All of those things become much more complicated because of the market uncertainty and the uncertainty with the travel and what's going to happen in industries and what's going to happen with people's income and what's going to happen with all kinds of things. So massive uncertainty, which is tremendously value destroying in a market. There's also logistical problems caused by people transitioning to working from home. And then there are places that are closed that normally play a role in transactions. So just to give an example, one of the most salient ones, it has to do with real estate transactions, both loans and conveyances. Normally, you would have a closing where somebody physically signed documents and those documents were physically notarized. That's kind of impossible if people can't come together for a closing. They recently passed the Secure Notarization Act, which allows people who are closing real estate transactions to go ahead and execute their documents. And this, of course, is not just for real estate. It would work for any other legal document, healthcare document, financial document. They could get a notary electronically in their own home. And so that's a good development for a situation where people cannot gather in physical proximity to one another. A little bit harder to solve is the problem of recording offices being closed throughout the country. Normally, when you have a real estate transaction, you want to immediately record the mortgage or the deed, or both. But if the recording office is closed, you can't do that. And so right now, the industry is kind of in flux, trying to figure out how they can get past this. There's this logistical problem, and maybe could they possibly do recording in a different way if their offices are closed. It's something that's generating a lot of discussion, but of course that also increases uncertainty and risk, which ends up being a disincentive to having these market transactions. So all of this is what's driving these companies to decrease their activity. It's driving stocks down. It's making people's ability to generate wealth really limited in this environment. Now, some have claimed that, wow, when they ordered a shutdown, they took away a lot of my economic value. This should be a takings. It should be unconstitutional under the 5th and 14th Amendment. Basically, it's a regulatory takings is the claim that the government seized my value against my will and they have to pay me just compensation. There's a fairly clear exception to a regulatory takings claim, or any takings claim, or regulatory, that basically that actions that temporarily destroy property values, that don't actually take title but destroy the value in the name of public safety or health that are required, that's not considered a takings. That's considered a valid government police power exercise. And the Supreme Court's held that for, 100 years now, that, for example, if they blow up a house to contain an out-of-control conflagration, a fire, that is seen as legitimate police power and isn't a taking, and therefore doesn't need to be compensated. So we have a lot of interesting business impacts. We have a lot of interesting individual impacts economically, and some responses starting and probably will be continuing to happen through the government. And there's a political aspect to this too. As people become economically more and more strained, there's going to be some pushback. And that's in addition to however they feel about the exposure that they have to the virus itself.
I wanted to talk to you today about precaution in the context of COVID, not as a matter of everyday precaution, but as a matter of how the law reacts to unknowns and how the law conceives of precaution. So the key thing about COVID that underlies a lot of the current market reaction as well as the governmental reaction is that there is a significant amount of scientific uncertainty surrounding how COVID-19 will spread, how fatal it is going to be, how it is going to mutate, and what actions against it will in fact prove effective and what actions will in fact not prove effective against it. So you find yourself in a situation in which decisions have to be made in the face of scientific uncertainty. So To give you an illustration of this, if you look at 538.com, the statistical modeling website that started out in sports, deals in politics, well, obviously there is a market now with COVID-19 for scientific uncertainty. They have mapped out the statistical response range of experts with regard to COVID-19 in terms of how many people are going to be infected, even in the short term in the United States, how fatal it is going to be, how many people are going to be hospitalized, long-term, short-term. And part of what 538 shows you is that there is a significant range in which even scientific experts are projecting the disease to go. So it is this kind of uncertainty that we're now facing as citizenry, as consumers, and that our governments are facing in order to formulate a response. So how do we react to precaution? Well, we react to precaution in fundamentally different ways. The European approach coming out of environmental law has been to say that to the extent that there is scientific uncertainty, that scientific uncertainty should not be taken as a reason for an action. This approach comes out of German constitutional law, Vorsorgeprinzip in German law, and this principle, precautionary principle, says to the extent that you ought to act in order to exercise precaution, in order to protect, then don't let scientific uncertainty stand in your way, or best do no harm, try to avoid as much as possible that which can create harm. As a common sense rule, that makes a certain amount of sense, but as American commentary in particular has shown, there is a real difficulty with that. And the difficulty that you encounter is that you start getting drawn into a problem as to, one, what is it that you're actually worried about? So to the extent that you want to have a precautionary approach, do you want to protect the ecosystem? Not relevant in this case, but relevant for the environmental source where it comes from. Do you want to protect human life? Or do you want to protect the economy? Depending as to which of these you're picking for precaution, you're going to find that the result is fundamentally different. So precaution is already driven by what is it that you want to protect. The other problem that you have with precaution is that the action that you take itself also has consequences. So there is no such thing as a consequence-free reaction to any one crisis, which means that to the extent you say, well, do no harm, better be safe itself, do no harm itself has consequences that need to be taken into account, and that, as Cass Sunstein and others have written, really fall outside the scope of the precautionary principle. Why is that? Well, part of what Cass Sunstein points out really powerfully in The Laws of Fear is that what precaution really does is it creates a heuristic, an implicit bias that is fear-driven. When we fear something, we react differently, and that limits the perspectives that we have. So part of what precaution frequently does is that it leads to a way in which we perceive information, a way in which we process information that confirms the fear that we already have, and that then drives decision-making in the same way. So that is fundamentally the problem that you run into when you talk about precaution in an environment that is as scientifically uncertain and as scary as this current situation is. So how do we get out of this problem? Well, what I do in my research about this is to say, look, you had to have discerning judgment. There are two things that I would want to recommend to you in terms of discerning judgment in order to avoid the precautionary problem. And that is, first, don't pick the worst case of the worst case modeling. Always look at the average worst case modeling as your base point for precaution. Given that we have such a wide range, there's a wide range of people to pick from. So look at 538 and other aggregators to look at what is in fact the average worst case scenario, and assume that that average worst case scenario is in fact what is the case. That is what we know. That is what we can deal with. The second point is you also have to then discerningly check what is the average worst case scenario for the action that I'm proposing. and then weigh these against each other in order to make common sense, prudent, and, it's law school, reasonable judgments. So I leave you with that thought: discerning judgment. Don't fall into heuristics. Always check the data. Do go with the worst case scenario in order to be cautious, but don't go with the worst case of the worst case. Don't fall for the outlier, of which there are many in reporting. Fall for an average, or go for an average of the worst case scenarios in order to have an appropriate understanding of what could go wrong and how we should behave to avoid it. I hope that was helpful, and look forward to discussing it with you more in the future.
100 years ago, a doctor at a hospital in Minnesota treated a child for scarlet fever. The patient's mother asked whether she and her husband, the patient's father, could visit their daughter safely. The doctor allegedly assured them that yes, they could, and they did. As a result, the parents said they contracted scarlet fever. The father sued the doctor for negligence. The doctor argued that the allegations, even if true, did not amount to a valid claim. The Supreme Court of Minnesota called the case a novel one, but the court applied long-standing principles of tort law and concluded that all the necessary elements of a cause of action based on negligence are present. We're talking now about the novel coronavirus, but the law about the negligent spreading of contagious diseases is reasonably settled. Here's how the Pennsylvania Supreme Court put it in 1937. If a man contracted smallpox through another's negligence, he would have a right of action. To be stricken with disease through another's negligence is no different from being struck with an automobile. The basic elements of any negligence case, whether involving cars or contagion, are a duty, a breach of that duty, causation, and injury. We all owe a duty of reasonable care, either to the world at large, or at least to those within a foreseeable orbit of risk of harm, as the Pennsylvania Supreme Court put it, in an opinion holding that doctors owe a duty to third parties who suffer harm when doctors fail to advise patients who've been exposed to a communicable disease about the risk of infecting others. For example, in a Texas case, when an employer was trying to treat an employee for smallpox but allowed the employee to escape from the treatment facility, the employer was liable to other people who later contracted smallpox from the employee. To decide whether a defendant has breached the duty of care, one must consider the reasonableness of the defendant's conduct. One way to do so is through Judge Learned Hand's controversial formula, holding that a defendant has breached the duty of care in failing to adopt a certain precaution if the burden of adopting it is less significant than the combination of the probability of harm and the magnitude of the resulting loss. In other words, Judge Hand wrote, the defendant is negligent if B is less than PL. Regardless of whether we apply the Learned Hand formula, a common precaution we can all agree on during the current pandemic is to use Learned Hand sanitizer. Here are some examples of classic cases in which defendants have breached the duty of care. In New Hampshire, a hospital assigned a student nurse to take care of a patient with diphtheria, but didn't warn the nurse of the danger of contagion. When the nurse contracted the disease from the patient, the hospital was liable to her. In Wisconsin, a couple hired a maid without telling her that their daughter had typhoid fever. After a couple of days, the mother mentioned the illness to the maid, but assured her that it was not contagious, and so the maid kept working. When the maid suffered her own attack of typhoid fever, though, she was able to hold the father liable for failing to inform her properly about the daughter's condition. In North Carolina, a husband was liable to his wife for failing to take steps to avoid infecting her with a disease of a foul and loathsome character, In that case, the foul and loathsome disease was gonorrhea, but the same principles would apply to COVID-19. What about the element of causation? In a 19th century case, the plaintiff sued a landlord for renting out a tenement that the landlord knew had been tainted with smallpox without warning the plaintiff or his family of 10, or taking any precautions such as ventilating the tenement or cleaning it with carbolic acid. The family moved in on May 5th, 1871, and by the end of June, the whole family had smallpox. When the plaintiff sued, the landlord protested that causation could not be proved because the source from which and the manner in which contagion is communicated is too uncertain and insusceptible of proof. But the Supreme Judicial Court of Massachusetts held that normal principles of causation applied. The defendant's negligence was an adequate cause of the injury. He cannot escape the consequences of his negligence upon the plea that the connection between cause and effect cannot be proved beyond possibility of doubt. The first negligence lawsuit about the novel coronavirus raises an interesting issue about the last element of negligence, injury. This past February, Eva and Ronald Weisberger, a Florida couple, set out for a long cruise from San Francisco. But after an outbreak of over 20 COVID-19 cases on the ship returned to California, where all the passengers were taken to land and put in quarantine. The Weisbergers sued Princess Cruise Lines, alleging that the company had been aware of a previous outbreak on the same ship and yet had failed to take proper precautions. The Weisbergers had not actually contracted the virus themselves, however. Instead, they alleged that they were at risk of immediate physical injury proximately caused by the defendant's negligence. Historically, courts have allowed recovery for fear of future injuries only if the injuries are more than 50% likely to happen. Recently, however, many courts have become willing to treat the risk of a future injury as an actual present injury, thus allowing plaintiffs like the Weisbergers to win. It's hard to predict the future of injuries or of litigation, but it is safe to predict that Weisberger versus Princess Cruise Lines will be only the first of many lawsuits that stem from exposure to the novel coronavirus, but that rely on traditional tort principles of negligence. Thank you.
My name is Professor Tanya Kowalski, and I'll be talking today about the likely effects of the pandemic on Indian country. Indian country is a federal term of art and also a term widely used to refer to Native American communities within the United States, and sometimes to the subset of those communities called the federally recognized tribes. It's really important for us to address this topic in the colloquium because Native American communities are so often ignored or marginalized. And of course, that can have especially devastating effects during a time of crisis. And so it's very important to understand how the pandemic will likely affect these communities. I thought it would be a good idea to start with just a very quick primer. We can't do it justice in the time that we have available, but for those who are less familiar with this topic, there are hundreds and hundreds of sovereign Indian nations within the United States. As of February 2020, there were 574 federally recognized tribes and dozens more tribes who are seeking recognition or who have state recognition. It's very important to understand that these are political entities within the United States. When tribes are recognized by the federal government, for example, they are engaged in what's called a government-to-government relationship with the United States, almost like a diplomatic relationship, but something more. The Supreme Court has described these nations as domestic dependent nations somewhat unfavorably, but embedded within that concept is that Native American nations have reserved sovereignty. And so they still have many aspects of their political sovereignty that they enjoyed before that would have been recognized by European powers, for example, and that they had inherently before the time of colonization. And so that still exists to this day, to the extent that they have not been usurped by Congress, for example. Although the effects on health are most paramount in our minds at this moment, it's important also to think about what the effects on tribal economies will be. These are developing nations within the United States. Most tribes are still recovering from the effects of colonization and will be for a long time. And so they are working hard to develop their own economies so that they can raise the standard of living for their residents, which and unfortunately, even though the United States has a treaty obligation to ensure that basic standard of living, it has not historically met that obligation. And so tribes are working hard for themselves to develop their economies. But many, maybe even most, are in really remote locations where they have to really create their own opportunities, which is one of the reasons why gaming has become so prevalent. And so many are reliant still on gaming as their primary employer, other than tribal government, and also for the income that they desperately need for basic services for their communities. And so the effects of the closures of gaming operations on Indian country are going to be devastating because it is so central to so many of those economies. And now to the effect on health services, most prominent on our minds right now. The United States, as one of its many treaty obligations to many tribes, owes Native American communities a right to health care and has created a federal agency for that called the Indian Health Service. It is chronically underfunded and understaffed, unfortunately, even going into this pandemic. And so it is disturbing to hear that the Indian Health Service is already starting at a deficit and is, of course, suffering even worse problems with the lack of supplies that it needs to deal with the pandemic, including personal protective equipment and more rapid testing. As of about a week ago, the reports were that although clinics did have some tests available, they were of the simpler swab variety that has to be sent to central labs. And with those kinds of tests, of course, it takes longer to get the results, making it more likely that there will be delays in isolating people, which will lead to much greater rates of infection and, unfortunately, probably also fatalities. To top it off, Native American communities already do not enjoy the best community health. There are high rates of diabetes and hypertension. And many Native Americans communities, because they suffer from the effects of rural poverty, also lack access to some of the important prerequisites for health, including safe drinking water, sanitation practices, and so on. And finally, a topic that may not be as obvious at first, but that is also likely to be devastating for some communities, is the effect of this pandemic on culture. And that's because so many cultural practices and native language speaking abilities rest with elders in the community. And of course, we know that elders are among the very most vulnerable. It's important to understand that one of the reasons why transmission of culture may have been broken or muted in many communities, and by that I mean the ability to transmit that culture from elders to the younger generation. Why that's been broken or interrupted in so many communities is that, or reduced, is because the United States engaged for centuries in a concerted official practice of assimilation. And it was this was up to approximately the 1970s, mid to late 1970s, and beginning in the 1800s, where the United States made a concerted effort to try to divorce Native American people from their native languages, their religious practices, and their other cultural practices in order to forcibly assimilate them into American culture. And one of the most pernicious practices among these was taking generations of children away from their families, forcibly removing them and putting them into boarding schools where they were forbidden from speaking their languages practicing their religions, and engaging in other types of cultural practices, including traditional knowledge, ceremonies, and so on. And so for that reason, even though there has been a great effort in tribes today to revitalize those practices and to make sure that they are safeguarded for the future, the rapid loss of elders would be a huge loss to that effort. And so unfortunately, I fear that it is probably creating a race against time at this point. And so finally, moving to our last topic, there is a right to health guaranteed in the law of international human rights. And this pertains also specifically to indigenous communities. And so the United States is a signatory or a member to several major international human rights treaties or declarations that guarantee health to its indigenous peoples. And that includes some of the ones that you see here, and specifically the aspirational version of that comes in a unique document created just for Indigenous peoples, which is the United Nations Declaration on the Rights of Indigenous Peoples. And it's important to know that in all of these documents, that it's not just the right to medical services, basic medical services that's guaranteed. It's actually also the right to the prerequisites for good community health. And so we were speaking a moment ago about how some communities, because of rural poverty, suffer from lack of safe drinking water and sanitary practices and so on. Well, that is actually, those fundamental prerequisites are actually guaranteed by international human rights law. So this is one of the areas in which the United States still falls short on its treaty obligations, and that unfortunately is likely to worsen the effects of the pandemic. Well, that's all for this presentation, but before we go, I would like to just take a moment to pause and recognize the past and present stewards of these lands that we enjoy in Kansas. Thank you very much for your participation.
My name is Bert Griggs. I teach natural resources law at Washburn University, and I'm going to talk briefly about how water law and water management policy provide a useful perspective on our current situation. I'd like to make 4 main points. First, like public health, with water we're dealing with a public resource. Water wasn't always viewed as a public resource, but starting in the 19th century, we came to realize that water must be a public resource to guard against speculation, hoarding, and inefficient use. Many state constitutions thus dedicate the waters of the state to the people of the state. We also saw public entities displace private water companies as water suppliers, such as in New York City. We decided we didn't want to entrust something as valuable as water and as clean and as valuable as clean water supplies to private entities. After the Great Flood of 1927 across the Mississippi River system, the United States Army Corps of Engineers built public flood control projects across the country. And many water rights, which are private property rights in the use of water, are subject to the public trust doctrine, especially in California. And almost all water rights across the West, and indeed across the country, are subject to public interest review. That is, whether it is in the public interest to allow such uses of water. My second point is that, like public health, we don't have a substitute for water. This makes water a unique natural resource in property law. Indeed, it's the resource to which we often turn for crisis metaphors. In times of economic crisis, such as right now, we speak of the need for liquidity flows, the need to prime the pump of the economy by making large infusions of cash. Keynesian economics is awash in water metaphors. But while the United States can print money, it can't make it rain. We have substitute resources for energy. We can substitute natural gas for coal for electricity generation. We can substitute natural gas for oil to heat our homes. We can also substitute hydropower, solar, and wind for natural gas and coal, replacing hydrocarbon sources with renewable substitute sources. We can substitute Gold and silver as the basis for our economy, as we did in 1893 when we went off the silver standard. Or we can go off the gold standard as we did in 1971. We can substitute one precious metal for another, or get rid of those precious metals as base metals entirely, because none of them have any inherent value, but water does. My third point is that, like public health, water law and policy raise hard questions of federalism. We are seeing this play out at the moment as some states issue shelter-in-place orders while others do not. Probably the most distinct difference right now is between the states of Louisiana and Mississippi. With water, the states generally have power over water resources and the allocation of water rights. There are, however, important exceptions to this rule of deference to state law. We have these exceptions because there are certain problems, regional flooding problems, interstate irrigation challenges, and water pollution that, like the coronavirus, do not obey state boundaries, and which raise problems and challenges that only the United States can confront. The most important water power at the moment is probably the Army Corps of Engineers. It has vast federal powers over managing the water supplies in our reservoirs and our dams, and managing the operation of our levees and flood control systems. States in the United States regularly clash over this division of power over water, and indeed there are multiple suits presently before the Supreme Court on this issue. My fourth point is that drought and flooding, like disease, are beyond our boundaries and our control. But when we fail to prepare, we create our own emergencies. It is becoming obvious that we were not prepared and are not prepared for the virus outbreak. The head of the Centers for Disease Control announced that formally this week. We've also been failing to prepare for water-related emergencies for decades. We're suffering from long-standing and worsening infrastructural decay of our levees, dams, and reservoir systems. And it's not just famously vulnerable cities such as New Orleans or Miami. It's also cities such as Sacramento or Fargo or Jackson, Mississippi. Global climate change is making these vulnerabilities worse. It's already made flood damage from hurricanes in the Gulf worse, and it's reducing the amount of water we have available for irrigation across the West and the Midwest. And so this summer, you may see the convergence of the virus and the water emergencies. I'd like to show you two maps. First, there's the most recent virus outbreak map. While the hardest hit areas are in the Northeast at the present, we are seeing more and more cases in the Ohio and Missouri River basins. The Corps of Engineers is dealing with this first emergency. It's building temporary hospitals across the country. Next, I'd like you to look at the United States Geological Survey's Water Watch map. This gives an index of flood levels in the rivers across the country. This spring, as the snows across the Missouri River basin melt and swell the levels of that basin and the Mississippi River, the Corps of Engineers will be dealing with that emergency as well. We may see these maps converge, the coronavirus outbreak maps and the flood maps in high populated river towns such as Kansas City, St. Louis, Memphis, and New Orleans. So where do these maps and the points I've made so far leave us? I'll end with two conclusions. The first is that all of our natural resources are connected. Water use affects land use and vice versa. Hotter air temperatures make for more violent flooding and more intense tornadoes, which contaminates and destroys land. Therefore, we need to think about our resources in an integrated way. But our legal systems are generally segregated, resource by resource, which makes this more difficult. And the second conclusion is this. If we are going to protect public health in this crisis and restore it after the virus has flooded through our population. We need to rebuild our public systems, especially our public water and health systems. And that is going to have to be a national, public, and largely federal effort, the likes of which we have not seen in a very long time, since the 1980s or so, when we began to turn our backs, not only on the public works projects, but on the public itself. Water is a public resource, so is public health, and thank you for watching this presentation.